on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself, state your name for the record.
Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right. So this is People versus Martin.
Yes, Your Honor, I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're going to proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated. I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while. That's correct. The issue here is that him and the victim are brothers. They live at their family
First,
home.
I want to deal with the whole bond thing, because
Yes.
his bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I believe I agree, and that's when the bond was changed. But Mr. Martin, Judge Kirsten, yes.
So Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to.
I mean, I have no objection.
Mr. Martin, now listen, you understand? I wasn't here, but Judge Kirsten, your original bond was $2,500 personal. Then he said it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything on whether there's an alleged violation of the bond condition. Is that right?
Not an alleged violation.
He
made comments.
He made a comment about it.
That he'll return back to the house.
This is why something. All right. So you understand you can't go to that house while you're on that. That's one of the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand it. I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No, listen.
Buckle up, guys. Today we're diving into a courtroom roller coaster featuring 4 sovereign citizens across 4 very different courts. Right from the opening, the tone is set. This isn't just legal drama, it's a front row seat to people confidently misunderstanding the law. The narrator lays out the lineup like a main event card, teasing updates, new faces, and guaranteed chaos, pulling viewers in before the first gavel even drops.
Listen, your objection is duly noted. You have very, very highly competent counsel. So let's let your counsel speak on your behalf. And so he already did. He made a motion.
Well, he's speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it. Stop interrupting. Your Mr. Darren made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. no contact with the victim or the victim's home location. And if you show up at that location and violate my bond, you could be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal, no contact with the victim, and no leaving the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial.
Your Honor,
Mr. Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't, but if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have an, I mean, I'm not going to, I'm advising him not to say anything, but Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step aside and let you stay.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so, but go ahead.
Okay, yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking. Now, I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself. So we'll hear everything you have to say about that at trial. Your objections duly noted.
All right, guys, we kick things off with Eric Martin, a familiar face who somehow keeps snatching defeat from the jaws of release. His attorney lays out a reasonable argument, too much time served, rules clearly violated, logic on their side. On paper, this should be simple. But anyone who's seen Eric before knows logic and Eric rarely share the same courtroom, and that tension hangs heavy in the air.
Do I have to
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have to
Sit down!
There?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested. You either go to the clerk's window now and get a trial date, or...
Here's where it all starts to unravel. The judge explains the bond conditions slowly and clearly, practically begging Eric not to self-destruct. And yet, right on cue, Eric insists on talking, rejecting reality in real time. This moment is pure suspense because freedom is right there, but his refusal to listen turns the hearing into a ticking time bomb everyone can see except him.
Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She is in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
Against all odds, the judge grants the bond, despite Eric doing everything possible to sabotage himself. It's one of those rare courtroom moments where patience wins over provocation. Still, the warnings are crystal clear, and the tone makes it obvious this is Eric's final lifeline. You can almost feel the collective disbelief that he was just handed freedom after arguing so hard against it.
That you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I did. I exited the courtroom and asked a police officer and probation officer.
Who has the indemnity bond?
Uh,
Where is the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down
either.
to the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest.
Stop fighting.
No, this is a false arrest.
Okay, relax.
This is kidnapping. They're violating my rights, my constitutional rights. I put in...
I thought the Constitution didn't apply to you.
The Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
All right, guys, buckle up again, because this is where stubborn meets consequences. We're introduced to a sovereign citizen Karen facing minor traffic charges with no jail time at all. The narrator spells out the absurdity, a maximum $300 fine, nothing more. Yet instead of resolving it quietly, she chooses confrontation, setting the stage for one of the most unnecessary courtroom disasters you'll ever see.
Frederick Falcon versus James Larry Warnicki.
Give this to the judge, sir.
Mr. Falcon, this is your case. So what is it you're asking for the court?
We purchased a house through tax deduction, and we're just asking occupants to vacate the property.
A tax foreclosure sale?
Yes, sir.
Okay, I see a copy of your sheriff's deed. You had it attached to the petition, and you purchased this on the first Tuesday of November, is that correct?
Yes, sir.
Okay, and after you purchased the property, I guess you realized it was occupied, and you served a notice to vacate. It says hand delivered.
Just with us know.
And by hand delivered, do you mean you actually handed it to him?
We tried to. There's a lot of signage up at the property. It's very intimidating. Gun, don't trespass, knocked on the door, left the letter.
Where did you leave it?
Front door.
It says hand delivered.
Yes, sir.
Okay, but you didn't hand it to anyone,
No one refused to answer.
sir?
No one answered. No
No
one
one
answered.
answered. So you just stuck the notice on the outside of the door?
Stuck in the door.
In the door, not on the inside of the
Through the crack.
through the
Went
crack.
in the house. Went in the house.
Okay, let me hear from you.
I never did see it,
Okay,
but
what's your opposition to this eviction?
I've got an unrebutted affidavit I sent to the Albert Uresti tax assessor around 2021. He didn't rebut it. So an unrebutted affidavit, as far as I know, it's a maxim of law. It stands as the truth of the matter. The truth of the matter is I don't know property taxes because I declared my house private.
This is the calm before the storm. The judge methodically explains the missed court date, the issued warrant, and the clear paper trail. There's no confusion here, only accountability. But instead of answering a simple question, the defendant immediately challenges the process, signaling that reason is about to leave the room and consequences are about to enter.
And private property is not subject to, only real estate is subject to income, property taxes. So that's what I couldn't understand, how they just went around an unrebutted affidavit like it was nothing.
Okay, so what you have is an issue of title, and I don't have authority to hear any issues of title. Okay? Not within my jurisdiction. You'd have to do that in a different courtroom, okay? But for today's purposes, you got very lucky because the way you served the notice to vacate doesn't comply with Texas law. You can't just stick it in the door.
Okay.
You have to put it on the inside of the main entry door. You have to look at Texas Property Code,
What do we do?
Section 24.
What if we do if he's not answering or not?
Well, that's what I'm telling you. Either hire an attorney or read Texas Property Code Section 24, and it's very specific as to how the notice has to be delivered. Now, the law is clear. It has to be delivered in certain ways, but it doesn't say they have to actually receive it. Okay?
Yes, sir.
Because I've had people say, I emailed it. Well, that didn't count under the law. You know, there's ways you have to serve it. And based on your testimony as to how you served it, it's not one of the legal ways to serve the notice to vacate.
Would I be able to serve the notice now?
I can't give you.
And here it is, the moment everything collapses. Her refusal to comply, combined with non-stop interruptions, pushes the judge past the breaking point. The arrest happens fast, loud, and on camera, transforming a $300 ticket into jail time. It's a brutal reminder that courts don't punish beliefs, they punish behavior, especially when warnings are ignored repeatedly.
It's going to be dismissed because the notice to vacate was not properly served, and you're going to have to start over. And so I would suggest we speak with an attorney about your title issue, if that's going to be your.
I've got another unrebutted affidavit here called the Executor's Entitlement Land Title, where I own the land
Okay.
under that
Again,
house.
I cannot determine who owns the land. I can only determine who has the superior right to immediate possession. That's the only issue before this court.
Well, hey,
That's the only issue I can address.
let me stop all this then. Let me just give him the house. I've already vacated. I've got another place to live. And I just want to settle this. After the reset that's coming up, we're going to have a global reset. I'm going to get the house back because I own the land.
Okay.
I'm a sovereign principal. I'm not a U.S. citizen. U.S. citizens can't own land.
Yes,
On a deed, a Texas deed, it says they're a tenant in peaceful possession. A renter, I'm not a renter. I own the land. And I don't own the house. He supposedly does because they just went around and my
Yes, sir.
affidavit like it didn't exist.
I have heard those arguments, sovereign citizen, multiple times.
No, sir. I didn't say sovereign citizen. I said a sovereign principal.
All right, guys, the scene shifts to Texas, where a homeowner tries to evict a sovereign citizen squatter. The judge keeps things grounded, explaining the law clearly and calmly, while the defendant leans on affidavits and buzzwords. This segment is fascinating because it shows how technical mistakes, not ideology, can derail even legitimate claims in court.
Through the Universal Will Court in Fort Worth, Texas, Judge Henderson, I can own land.
Okay, but those issues, I cannot hear those issues.
Okay.
This court
Well,
does not have
just give him the
jurisdiction.
house then?
So are we in judgment then if you've,
I can't give you a judgment because you didn't properly serve, but he's telling you he's surrendering the house. You give him the keys and that's official surrender of the house.
Okay.
Okay, and then you probably don't have to file anything. You don't have to come back. You're gonna get your house.
I'm doing him a favor. I want to
Go
be
on.
done with this.
Yes,
I'm going
sir.
to get the house back.
This is a rare sight, a sovereign citizen actually backing down. After all the talk of unrebutted affidavits and land ownership fantasies, reality finally sets in. He surrenders the property, choosing peace over performance. It's an unexpected ending that highlights how quickly confidence evaporates once courtroom theatrics meet firm legal boundaries.
Lamech Thomas had an
Yes.
announcement to the court, I believe.
Yes, I would like that announcement. I was gonna ask. Go ahead.
All right, so I won't be needing an attorney. I'll be representing myself as my trust. I'll be representing my trust. I wouldn't need an attorney for.
Okay, what you mean by your trust?
I'm sorry.
What you mean by your trust?
All right, guys, we end with a masterclass from one of the calmest judges you'll ever see. With patience and precision, she dismantles every sovereign talking point without raising her voice. No theatrics, no insults, just law, experience, and clarity. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.